You can put us on, Shannon. Okay, this is the matter of Curl versus Orr. And Shannon Page Curl is present on my Zoom screen. Ms. Curl, you can hear me?
Yes.
I can't hear you.
You can't or you can?
Check your sound settings. All you did, you just muted your microphone. I think you need to. Well, wait, no, I'm sorry. The problem's at my end.
Okay.
Muted your microphone.
I don't think that's what.
Well, wait, no, I'm sorry. All right, can you stop or mute the YouTube that's running?
Yeah, I don't think I have YouTube. Oh, live on YouTube.
All right, maybe the problem's at my end. Hold on a minute. We're picking up some sound. Is there any sound at your end? A radio or something?
I hear something, but I don't know. I don't have anything else open on my laptop.
Let me check some of my browser windows.
Let's honor each other by putting edges in place to make sure we don't. And that falls back to what I was saying.
Yeah, I don't know where that's coming from. There's something bleeding over my speaker.
I can hear it, but it's not from my end.
Yeah, it's a radio program of some kind, but I'm looking at.
Observe behavior. Yeah. Yeah. So I'll go back to the story chronologically. It had been going on for like years, but still, very terror, affecting knowing that in the cycle.
You did this.
And after 3 years, it's a reality. So. And then,
Okay, we found the culprits. Sorry
Yeah.
about that.
No, you're fine.
Our the technology we normally use to do Zoom hearings is not working for some reason.
Okay.
So I have a backup that I can use, and we don't use it very often. All right, we're gonna have to go with this. Okay, so now, Ms. Curl, you filed an objection to custody order. To your knowledge, is Mr. Orr still in jail?
To my knowledge, last Thursday was his sentencing hearing when he was sentenced to 365 days in jail in Eaton County. So to my knowledge, and last that I knew of, yes.
All right. When we are aware that a party to a proceeding is in jail, I can't really go forward without giving him an opportunity to participate. Because we weren't aware that he was in jail, we weren't able to make any advance arrangements for him to participate. But let me, as long as I've got you here, I looked at your objection to the custody order. One of the things you said is you want sole physical and legal custody. The custody order gives you sole physical and legal custody.
Yes. I also wanted to say I called the judge's assistant last week and told her Tyler was in jail, and called her again on Monday and told her Tyler was in jail. And she said, thank you for letting me know. So she's known for about 2.5 weeks now.
Well, the judge who needed to know was me.
Okay, because I called the judge's, they told me that they would tell the judge's assistant and she would tell you.
Yeah, I don't have any information other than what you submitted. In any event, uh, the order that you objected to, the proposed final order, gives you
Yes.
sole legal. It says primary physical, but in effect, it's sole physical
Yes.
because all he gets is supervised parenting time.
Yes.
And I realize you want his parenting time suspended, but what possible danger is there if his parenting time is being supervised? According to this order, it says supervised by a professional.
Yeah, so I just want it suspended, obviously, until he gets out of jail. And then,
Oh, absolutely. He won't get parenting time while he's in jail. We don't need a provision in your order that says that. It's automatic. If you're in jail, you don't get parenting time.
okay. And then after, I wanted it just until he was ready to start parenting time again. Because if you see there, he pled guilty to 2 CSC charges.
I saw that.
And I'm just worried at
So
some point it would move out of the court system and out of a professional supervision.
uh, only if he succeeds in filing a motion to modify this final order. So this final order remains in place until a new order gets entered.
Okay.
So the only way he could get anything other than parenting time supervised by a professional is he would have to have file a motion. You would get notice of that motion. You would have the opportunity to appear and object to whatever it is he's asking for. And at that time, we can decide, is he a danger? I don't know the underlying circumstances of his charges. Certainly they are concerning to me, just as they are to you.
Yes.
But when we have a situation where a parent is charged with a sexual offense and it involves the minor child or a sibling of the minor child, you're right. Typically, we would totally suspend. In this case, it involves somebody else, and there's nothing to indicate that having supervised parenting time would pose any risk of harm to your child.
Okay.
So if you withdraw your objections, this order will proceed as the final order. You will, even though it says primary custody, because it doesn't give him any parenting time, it effectively gives you sole custody.
Okay.
The only parenting time he gets is supervised, and the only way that's going to change is with a court order.
Okay.
So now that I've explained all of that, are you okay with withdrawing your objections?
Yes.
Okay. I will enter an order to that effect. This proposed final order will now be the final order. And that won't change. And like I said, unless he asks for it to be changed, or unless you ask for it to be changed.
Okay.
But this will be the governing order. Okay?
Thank you so much.
You're welcome, ma'am. Have a good day.
You too.